Your name?
And here we go, the first case of the day. Charles Williams steps up, and right out the gate, he's waiving his right to a preliminary examination. Translation? We skipping the mini-trial? Where the state has to prove probable cause. Bold move, Charles? Or just tired of dragging this out?
Charles skipping his prelim? That's like saying, nay, I don't need the dress rehearsal, let's head straight to Broadway Bold. But risky viewers, would you gamble your shot at poking holes in the state's case this early?
Sure. You're a prosecutor. What? No. Take your time.
I'm so sorry. It's here to desperate people.
All right. He's waiving.
Yes, Your Honor. You have to sign.
I do. Mr. Williams, you're waiving the right to a preliminary examination?
Yes.
You understand a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes.
People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Burke.
I'm going to agree on behalf of Charles Lee, waiving and request retrial.
Defendant having waived formal reading.
Now he's bound over legal jargon for welcome to the big league circuit court isn't just a step up, it's where the punishments get heavier. Think of it as leveling up in a video game, except every boss fight could land you in prison.
Standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for April 9th, 2025.
Quick and clean, the judge just bound him over to circuit court. It means the real fight moves upstairs, where the stakes and penalties get a whole lot bigger. Think of this as leveling up, except you don't really want to be playing this game.
1:30, Judge Conlon.
You guys bound.
Bound, continue.
Thank you.
Court does call the case People versus Micah Jones.
Hey, we're to desperate people.
Go ahead.
Good morning, Your Honor. Assistant Public Defender Ben Dunaway. On behalf of Micah Jones, who stands to my right. Mr. Jones, would you state your name for the record?
Thank you. He's waiving.
He is waiving, Your Honor. He is signing the form right now.
Sir, you're waiving your right to a preliminary examination? You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand you'll not have that hearing and you'll proceed to circuit court for further resolution. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on the single count. Counsel, your turn.
One date, Your Honor?
You waive reading of the information?
Yes, sorry. Stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
April 7th.
April 7th, 2025, 1:30, Judge Hamoud.
Thank you, Your Honor.
Thank you. Bond continue. Court does call the case of the People versus Calvin Fuqua.
So, Mr. Grant, on behalf of people, Your Honor, Brown Street, on behalf of
Your name, sir? Thank you. Is he waiving? Okay.
This is the date and time set for the examination. The officer involved was informed by the officer to start off with the consent notice there for today's date. He was failed to appear to be part.
Move to dismiss.
People being unable to proceed, this case is dismissed. That's on defendant's motion without prejudice. Thank you. Court calls case People versus Zenyi Yu.
The judge is on behalf of the defendant will speak.
Whoa, case dismissed. That's a legal knockout. Whoa, but notice the key phrase, without prejudice. That's... Lawyers speak for, we're letting you off the hook today. But don't celebrate too hard, because they can file charges again.
Roll up.
Thank you.
Today's date time set for the examination. At this time, if you are unable to proceed as count one, I would ask the court to remand on counts 2 and 3.
No objection to this dismissal.
Count 1 is dismissed. The case is remanded to the 15th District Court on counts 2 and 3. I'll set a pretrial date,
April 16th at 9 a.m.
April 16, 2025, it's at 9 a.m. 9 a.m. before Judge Perry.
You've already given my client permission to go to California.
I did?
She returned for today's date. She wants to return to California. She'll make her court dates. Judge Perry usually allows that. So we're asking permission to return.
No objection from people who have already.
So she normally resides in California, is that?
After this today, Your Honor, she re-engaged for mental health treatment. She's based in California.
Okay.
And that is her permanent.
So what I will do is her bond will continue. Defendant may travel.
Whoa, case dismissed. Sounds like a win, right? Not so fast. The judge said, without prejudice, which is lawyer code for well be back. It's like hitting pause on a horror movie. You know the monster's still out there.
And she resides in California, correct? Right.
Yes.
Okay. So I'm going to word it this way, that she may travel and reside in California.
Okay, now this is interesting. The defendant actually gets to head back to California while this case plays out. That's unusual. You usually have to stay local when on bond. It shows the judge is trusting her, which in court is about as rare as free parking on Monopoly.
Must return for court dates or court proceedings. Of course, if Judge Perry allows them. Right, thank you. Court calls the case People versus Tamia Harris.
Hey, everyone, this will be forward.
He was lurking around all morning. Next to him? Bernstein? You know where he is? Okay, gotcha. Appreciate it.
The judge actually lets her travel back to California while on bond. That's rare. Normally, bond rules keep you locked to the city like it's house arrest light translation. This judge is giving her a lot of trust. Let's see if she earns it.
Your name? All right. I have before me a plea form, and I'm assuming this was supposed to be an attempted. And it's okay. The huh? You messed this all up. Hold on. I don't know if my pack codes are. They're not. They're not. You did. Jeez, oh Pete. No, don't worry about it. I'll fix it.
Clerical chaos. Messy paperwork in school means a bad grade. Messy paperwork in court can mean a bad decade. Judges hate fixing sloppy forms, but hey, one wrong word here can change someone's entire future.
Away, paperwork. Chaos in the courtroom. Even judges aren't safe from clerical errors. And here's the thing. One wrong word on that plea deal could change someone's entire future. Messy handwriting in school, bad grade. Messy plea form in court, bad decade.
So I think how this is supposed to read, and now kind of does, that she's going to be pleading guilty to the charge of attempted resisting and obstructing a police officer, the 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of it.
Yes, sir.
Man, what was someone?
Where
You have gum. Check that. Oh. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing a police officer. Is that correct? That's a misdemeanor, punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that? You understand also that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
Understanding all of that, do you still wish to plead guilty? And to that charge, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form today, is that correct?
Yes.
Any question regarding any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily of your own free will.
There it is, the aha moment. She admits to grabbing someone's arm during an arrest. Sounds small, right? But that tiny act is enough to turn into a criminal charge. Quick question. Do you think she realized in that split second she was writing herself into a misdemeanor?
And because you believe that you're guilty of this offense? February 8, 2025, at the location of 1490 DeSoto in Ypsilanti Township, Washington County, State of Michigan, did you come into contact with police officers?
Yes.
What happened that makes you think that you're guilty of this offense?
I was interfering officer with
So somebody was being arrested.
Yes.
You knew they were being arrested, and you interfered with that arrest. How did you do that? Okay. And you knew it was a police officer doing that.
Yes.
Correct. All right, counsel, have I complied with the court rules?
Yes, sir.
Court will accept the defendant's plea to count 2. Plea of guilty.
And there it is, the aha moment. She admits she grabbed the arm of someone being arrested. That tiny action is enough to flip this into a criminal charge. Folks, interfering with an arrest never ends with you winning. It ends with you standing exactly where she's standing now.
To count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
At 10 a.m. before Judge Washington.
May 15, 2025, 10 a.m. before Judge Washington. So when you grab the arm, how'd that work? Not well. Yeah, okay. Just check it. Bond will continue. All right, thank you. Yeah, it didn't work out well because you're here. Thing isn't it? Figured that out on my own. Court calls the case. People versus Anita Pain.
They have no choice. We're not even people. We're ready. That's fine.
Hello, my name is Anita Pain.
All right. I have before me a plea form that indicates defendant will be pleading guilty to attempted custodial interference or kidnapping custodial interference, the 6-month offense. Upon her successful plea to that charge, the kidnapping charge, custodial interference, would be dismissed. There is further the agreement, although, well, I guess it's me, it's okay to seek a deferral pursuant to statute.
That's all.
That's the court's full understanding of the agreement. Is that correct, Mr. Brown?
That is correct, John. Thank you.
Ever sworn?
So I swear to keep the whole thing from the truth, all we got. That's correct.
My name is Anita Pain.
Sure. Go ahead. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of attempted kidnapping custodial interference. Is that correct? That is a misdemeanor punishable by up to 6 months incarceration and a $2,000 fine plus court costs. Is that?
Yeah.
All right. Understanding all of that, do you still wish to plead guilty? And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind. You signed an advice of rights form, is that correct? Any question regarding any of those rights? Please look at paragraph 5 on that form. Those are your rights which are part of the trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights. You understand you're giving up your right to appeal of rights. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to?
Yes, sir. Oh, no.
All right, let's try that again. Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge? Has anybody threatened you or coerced you? You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty?
Yes.
December 2nd, 2024, at the location of 4511 Packard Road, Pittsfield Township, Washtenaw County, State of Michigan. Did you have custodial possession of a child at that time? Physical possession?
Yes.
All right. And at the time that you had that physical possession of the child, was that child supposed to be returned to the other parent?
Yes.
At that time? And had a 24-hour period passed?
Yes.
Since, I guess I should clarify that. The child was supposed to be returned at least 24 hours prior to the time that you got.
Yes.
All right. And you just failed to do so.
Yes.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor, the people are set. It's set.
The court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be.
It's got a TV docket.
Sure, it could. I can put it wherever I want. No, what? You're saying that's where you believe it belongs?
April 1st at 1 p.m.
Sentencing will be April 21st, 2025, 1 p.m. And that's before me. Yes. I saw you sign the sentencing judge waiver, and I didn't know why. Was he trying to, not have me? What was he trying to do? He was up to something. What? Oh, okay. Yeah. All right. It'll be before me on that date. On your way out, you may want to stop by my probation department to get that started, that process. All right? What?
What's the date? Or
April 21st at 1
that's it.
Well, I was going to set another date, but then Childers jumped in. So I set another date, and you weren't listening. The only person that was listening was your client. Are you good, Navaleo? Are you good? I know you're good. Are you good? Okay, bond continued. What? No, it's at 1. I don't know why I bother talking. just like go.
I got it.
You got it? Finally? Ma'am, what date did he write down?
The 21st at 1 p.m.
Okay, good enough. All right. Thank you. Just double checking. Court calls the case of the people versus Robert Jones.
As then, we have
So public defender, we got Mr. Jones. With the motion claim now, Mr. Jones, statement for the record, please.
All right.
It is going to be no comments.
We have a form that indicates that the defendant will be pleading no contest to the charge of aggravated domestic violence, the 1-year offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. There is the agreement between counsel of no upfront jail. We don't do that, but you see that that's the agreement, understanding of counsel.
That's fine.
All right. Is that a correct statement? All right, let's have him sworn.
Raise your right hand.